previously we had started with your unit on the Sale of Goods Act 1930, and under the Sale of Goods Act we had already discussed about the sale of goods, the introduction to the Sale of Goods Act. We saw the definition of the term sale, and also we saw some important elements or the essential elements which are required for a contract of sale of goods to exist. At the same time, we also saw the term sale and agreement to sell, and we learned about the differences between these two terms, and at the same time we also saw about sales and hire purchase agreements and the differences between the two. Now, a very important element when we were talking about the different essential elements or characteristics of a sale of goods was that the subject matter is supposed to be goods. Right, there was a term, there was a element or characteristic of the sale of goods which we read as subject matter is required to be goods. So the next topic we're discussing is with regards to goods. So again, the subject matter in Sale of Goods Act is the goods. So let's look at the meaning or the definition of sale of goods as per section 2 subsection 7. So we've already seen this definition when we're discussing the essential elements, but just a quick reminder. Definition of goods. Goods means every kind of movable property other than actionable claims and money, and includes stock and share, growing crops, grass, and things attached to or forming part of the land which are agreed to be served before sale or under the contract of sale. Okay, this is the meaning or definition of goods as per section 2 subsection 7. Now, on the basis of this particular definition, we can have classifications of goods under 3 categories: existing goods, future goods, and contingent goods. So from the name itself, existing goods are those goods which are at the possession or which are existing at the time of sale. Future goods are the goods which are not yet in existence but which will exist later, and contingent goods are those goods which may be required for sale or may not. Okay, so it depends upon certain situations. So firstly, let's look in detail about existing goods. So existing goods, as we've already said, it refers to those goods which are either owned or possessed by the seller at the time when they're entering into a contract of sale. Now, these goods are going to be physically in existence as well as in the possession of the seller at the time of sale. At the time of sale itself, these goods are already with the seller himself. And your existing goods can be subclassified into specific goods, unascertained or unsanctioned goods, and you have ascertained goods. So firstly, specific goods. Now, specific goods have been described under section 2 subsection 14. Okay, specific goods are under section 2 subsection 14, and these are the goods which are identified and agreed upon at the time when a contract of sale is made. These are the goods which you have agreed to buy or sell specifically at the time of when you're entering into the contract. Now, goods are not specific merely because they are capable of identification, but they must be actually identified. They should not be, I will buy a book. Rather, I will buy this book, the name of the book, and so on and so forth. Okay, for example, you have 2 parties, A and B, and A agrees to sell his car to B. So in this situation, it is a sale of specific goods. Okay, he's not saying, I will sell you my property. If he's saying, I will sell you my property, it becomes ambiguous. It becomes very vague. Which of your properties are you going to sell? Are you going to sell your house? Are you going to sell your car? Are you going to sell your scooter? Okay, so in that situation, it is vague. But if you have specifically mentioned, I am going to sell my car to you, then it becomes a specific goods or a specific sale of goods. All right, and the next category of existing goods are your unascertained goods, also known as unsanctioned goods. So these are the goods which are not identified or agreed upon even at the time when the contract of sale of goods is made. So these are generally like in the case of goods which are lying in stock. Okay, so these goods are indicated or defined only by their description. For example, if you say, I want to buy books, but which books do you want to buy? You haven't defined, but out of the stock of the seller, you want to buy books. That is for sure. Okay, so these are termed as unascertained goods. So let's take an example. Again, let's take an example of 2 parties, A and B. Now, A is the seller, and A has agreed to sell, let's say, 1 bag of rice to party B. Now, this bag of rice is going to be taken out of 50 bags of rice. Okay, let's say in his warehouse, he has 50 bags of rice, and out of those 50 bags, he's going to sell only 1 bag to your party B. So this becomes uncertain because we do not know which bag of rice is the one that is to be sold. Okay, so in case of uncertain goods, always remember it's generally used in case of goods that are in stock or goods that are lying in lots. And the third category under existing goods are your ascertained goods. Now, goods are said to be ascertained when, out of a mass of unascertained goods, the quantity extracted for is identified and set aside for a given quantity. So, when it comes to ascertained goods, these are those goods which out of unascertained goods. Okay, these arise out of unascertained goods. So, for example, again, let's say, again, you have two parties, A and B. A has agreed to sell one bag of rice to party B, and he has already written on that bag of rice for party B. He has marked it out of all those 50 bags, he has marked one bag specifically for party B. Then it's termed as ascertained goods. Okay, so when a part of goods which are lying in bulk are identified and they have been pointed out or earmarked for sale, then these goods are termed as your ascertained goods. And the next category of goods is your future goods. So future goods is mentioned under section 2, subsection 6. And future goods refers to those goods which are not yet in existence at the time of entering into a contract, or maybe they are in existence but they haven't been procured, or they haven't been acquired yet by the seller when they are making the contract. Okay, so under this situation, there can only be an agreement to sell. You cannot sell because there is no physical goods with you, but you can only enter into an agreement to sell, wherein once the goods are ready, then you'll sell them. Okay, there can be no sale in respect of future goods because one cannot sell what one does not possess. All right, and then the third category of goods are your contingent goods. So contingent goods are under section 6 of section 2. Now, when we are discussing about accounts and all that, you might have heard of the term contingent liability, right? That is something that may or may not happen. Similarly, in case of contingent goods also, these are goods, the acquisition of which by the seller depends upon a contingency which may or may not happen. That means these are goods which will be acquired by a seller, which will be acquired by a buyer depending upon certain conditions. So, in fact, contingent goods are also constituted under future goods itself. So, let's take an example. A has agreed to sell some kinds of goods to party B. Okay, A has agreed to sell some goods to party B, and these goods are arriving on a particular ship. And he has promised that once the ship arrives at the country, once the ship arrives at the port, then the goods will be sold to him. However, let's say the ship arrives at the port, but the ship does not carry the goods on it. Okay, the goods that they wanted to sell are not on the ship. Now, in that situation, it is not the fault of the seller, right? Rather, it's the fault of the people who have not put the goods on the ship. So, when the ship arrives and the goods are not on board, that means the liability is not of the seller because he has entered into a contract to deliver the goods when they arrive. Okay, so on the happening of an event only. He did not say that on that date I will deliver the goods, or when something happens, then I'll deliver the good. Rather, he said, when the ship arrives, when the good arrives, then I'll deliver the goods. Okay, so on the happening of an event, these are contingent goods. So always remember, in case of contingent goods, they are generally future goods, but they can also be specific goods. So mostly future goods and specific goods. So these are goods, the acquisition of which by the seller depends upon a contingency which may or may not happen. All right, so these are about your goods. Next, we're talking about the effect of perishing of goods. What happens in case goods die out, or in case the goods they perish before a sale is completed. So in a contract of sale of goods, the goods may perish before a sale is completed. So when we're talking about perishing, it's not just the damage that has happened. Maybe if your fast-moving consumer goods, maybe in case of food stuff, maybe somebody stole the food, or maybe the expiry date has arrived also. Okay, this also is perishing. So a contract of sale for the sale of specific goods is void at the time when the contract was made. The goods have, without the knowledge of the seller, perished. Okay, so in case of a contract of sale, specific goods, the contract can be void if, without the knowledge of the seller, the goods have perished. Now, the same would be the case where the goods become so damaged as no longer to answer to their description in the contract. This is as per section 7. So in case the goods can no longer, in case they get damaged, that you can no longer recognize them as the original description, then in that situation also it's said that goods have perished. So in case goods have perished after the agreement to sell, but before the sale is effected, you have agreed to sell, but you haven't yet delivered the goods. So in that situation, in case the goods perish, then as per section 8, an agreement to sell specific goods becomes void if subsequently the goods without any fault on the part of the seller or the buyer perish or they become damaged so as to no longer answer to their description in the agreement before the risk passes to the buyer. Okay, so if the goods haven't been delivered and if they are damaged, not due to the fault of the buyer, neither due to the fault of the seller, then in that situation the contract becomes void. Either party does not have to fulfill their part of the contract. Okay, so fault basically means wrongful act or default. Now, perishing goods, they affect sales contract in different ways depending on what point the goods have become unfit for sale. So generally, whoever owns the goods is going to be responsible for taking care of or handling any damages to the goods. So therefore, parties will take on varying risk or varying degrees of risk throughout the sales process. And as I said earlier, perishing of goods does not mean only physical destruction of goods, but it also covers areas like damage to goods so that the goods have ceased to exist in the normal commercial sense. Okay, that is, they have been destroyed in such a way, they're not physically destroyed, but they have been destroyed in such a way that they can no longer be sold. All right. So, for example, where you have salt, if salt has touched water, then it melts, it can no longer be sold. Similarly, in case you have cement also, if it's spoiled by water, it becomes stone, then it cannot be sold again, it becomes unsaleable. And next you have in case perishing due to loss or theft also. So even due to loss or theft also, you can it also leads to perishing of goods and then also loss of commercial value. In case they cannot be sold anymore, then that is also termed as perishing of the goods. Now, where specific goods form the subject matter of a contract of sale, both in case of actual sale as well as in an agreement of sale, and if these specific goods have perished without the knowledge of the seller or even before the time of contract, then in that situation the contract will be void. Now, this provision is made either on the group of mutual mistake as to the matter of fact essential to agreement or on the ground of impossibility of performance, both of which render the contract void ab initio. So in case of specific goods which have perished either before or even during the time of contract, then in that case the contract is void, and the voidability of a contract is based upon the fact that it is due to impossibility of performance or maybe due to even mutual mistakes on both parts. All right, then that situation, it leads to a contract which is void ab initio. Next, we'll talk about the performance of a contract, how a contract is going to be carried out. Now, the performance of a contract basically refers to a contract of sale, basically refers to delivery of goods by the seller and the acceptance of the delivery of goods and payment for them by the. Therefore, whenever we note performance of contract of sale, it means nothing more than delivery of the goods, such that the buying and selling, the sales and the purchases is terminated. You have sold the property and you have received consideration for that particular property. So the parties are free to provide any terms that they like in the contract about the time, place, and even the manner of delivery of goods, and then after that even with regards to the acceptance of payments and also the price for the products. However, if the parties are silent and they have not provided anything with regards to these matters in the contract, then the rules contained in Sales of Goods Acts will become applicable. Now, if the contract contains any kinds of special terms as to delivery and acceptance, then these must be complied with. For example, if they say in case of goods which are quite fragile. So in case of goods which are fragile, maybe in the contract is mentioned that these goods have to be wrapped in bubble wrap or they have to be wrapped in a lot of foam. And if then that means the seller has to comply with all of these special terms in the contract. Now, if there are no terms in the contract with regards to any special terms to this effect, then delivery and payment of goods and the prices also of the goods are based upon concurrent conditions. That is, both of these must take place at the same time. So, whenever you're purchasing, you can pay for it at the same time. So, their buying will be followed by a payment. Okay, so unless of course there are already conditions, terms and conditions should state there will be credit purchase or sale, right? Other than that, if there are no other agreements mentioned in the contract, then it will always be a cash sale or a over-the-counter sale in a shop. Then you have with regards to delivery of goods. What exactly do you mean by delivery of goods? So as we've said earlier, in order to carry out or in order to fulfill a contract of sale, there should be a delivery of goods and there should be a receipt of money. So firstly, what is delivery of goods? Delivery, it means a voluntary transfer of possession of goods from one person to another. And as we've already seen in case of Sale of Goods Act, there must be two parties, the buyer and the seller. So delivery basically means transfer of goods from the seller to the buyer. And delivery of goods may be made by doing anything which the parties shall treat as delivery, or which has the effect of putting the goods in the possession of the buyer or his agent. It's not necessary that only the buyer should receive the goods, but even his agent also can receive the goods on behalf of the actual buyer. And delivery of goods may be actual, symbolic, or constructive. So there are three types of delivery of goods. It is actual delivery, symbolic delivery, or constructive delivery. An actual delivery is basically a delivery wherein the goods are actually handed to the buyer. For example, when you're going to buy a pen, so you go to a shop, you get a pen, and the pen is handed to you physically. That is actual delivery. And symbolic delivery is when you're handing out just symbols that show you are transferring possession, like in case you're handing a key to a house. Okay, so that will be a symbolic delivery of goods. And then you also have constructive delivery of goods, where it is mostly in regards with a third person. So let's look into these one by one. First, actual delivery. Now, as we said earlier, when the goods are handed over by the seller to the buyer or even to his authorized agent, then the delivery is said to be actual. So delivery of goods may also be made by doing anything which has the effect of putting the goods in the possession of the buyer, other than just delivering in actuality, delivering just the goods from one hand to another. It could also be through the transfer of possession, that is ownership also. You can just transfer the documents, that will also be termed as a delivery. And next you have symbolic delivery. So when the goods are ponderous, when they're bulky, when they're incapable of actual delivery, okay, in case of fixed assets, or in case of really huge assets which you cannot transfer from one person to another, or maybe even in case of a haystack in a meadow, right? In that situation, it's all symbolic delivery. You cannot hand over the asset, you cannot hand over the property. So you're handing over something which shows that you have handed out the properties. As we've said earlier, handing over a key is a symbol that you have transferred the asset to that particular property. So handing over of a key to a warehouse to the buyer is a symbolic delivery of the goods to the buyer, and is in fact as effective as actual delivery, even though there is no change in the possession of the goods. Okay? Even though the goods do not transfer from one person to another, but the ownership transferred. So that is also termed as delivery. And the third kind of delivery of goods is constructive delivery. So when you have a third person, like a bailee, who is in possession of the goods of the seller at the time of sale, and he acknowledges to the buyer that he holds the goods on behalf of the seller, then the constructive delivery can take place. Okay, so if you have a third person who's holding the goods for the seller, and this third party or the third person goes to the buyer and says, I'm holding the goods on behalf of the seller, then it's termed as a constructive delivery. So this can happen in case the seller is in possession of the goods. The seller who has provided the goods agrees to hold them on behalf of the buyer, or when the buyer is in possession of the goods and the seller agrees to the buyers holding the goods as owners, or when the third party is in possession of the goods and acknowledges to the buyer that he is holding them on his behalf. Okay, so these are your three kinds of deliveries. Then let's talk about the rules with regards to delivery of goods. What is required, what is to be followed as per the Sales of Goods Act. So the Sales of Goods Act 1930 provides the following rules regarding delivery of goods. First rule is under section 33, which is regarding delivery. So the delivery of goods can be made either by putting the goods in the possession of the buyer or any other person authorized by him to hold them on his behalf, as we've already seen, actual delivery, constructive delivery, all of those, okay? And the delivery of goods, again, actual, symbolic, or constructive. Next part, effect of part delivery under section 34. Now, if a part delivery of the goods is made in progress of the delivery of the whole, then it has the same effect for the purpose of passing the property in such goods as the delivery of the whole. So when you're doing a part delivery, it's almost equivalent to doing whole delivery. However, a part delivery with an intention of severing it from the whole does not operate as a remainder of the delivery. In case you want to, there is a product and you've divided in the product and you've delivered only a part of the product with the intention of not delivering the rest of the product, then in that situation it cannot be termed as a delivery. Okay, and then you have buyer to apply for delivery under section 35. Now a seller is not bound to deliver the goods until the buyer applies for delivery, unless of course the parties have agreed to the terms in the contract, which means that if the buyer has not said that he wants the goods to be delivered, then the buyer can keep the goods. If the buyer has not said that the goods should be delivered to him, then the seller is under no obligation to deliver the goods to the buyer. Okay, it's always the buyer who should apply for the delivery of the goods. And under section 36 subsection 1, you have place of delivery, which states that depending upon the contract of sale, the agreements between the parties with regards to delivery, then the buyer may take possession of goods from the seller, or the seller might send the goods to the buyer. And however, if there are no terms mentioned specifically in the contract, then as per the sales law on sales, the goods are delivered at the place at which they are at the time of the sale. So if the goods are in location A, then they're going to be delivered only to location A, because that is where they are at the time of sale, if there is no contract that has been entered into. As per the law of sales, the goods to be sold are delivered to the place at which they are at the time of a criminal sale. However, if the goods are not in existence at the time of such sale, then they can be delivered to the place where they are going to be manufactured or where they are going to be produced. Okay, and point number 5, time of delivery under section 36 subsection 2. So a contract of sale where the seller agrees to sell the goods to the buyer, but not the time of delivery is specified. So under this situation, if the time of delivery is not specified, but only the place of delivery is specified, then the seller is expected to deliver the goods within a reasonable period of time. That is, however much time is going to be taken in general to produce a particular product. So within that specific amount of time, the goods should be delivered to the buyer. And the next point, time for tender of delivery under section 36 subsection 4. So it is important that the demand or the tender of delivery is also made at a reasonable hour. If not, then the contract of sale will be rendered as ineffectual. And the reasonable hour will depend upon the case. Generally, reasonable hour will be the office hours between 9 to 5 o'clock. However, if it's a residential place, then it could even increase up to between 7 to 7 o'clock. Okay. And next you have expenses for delivery, section 36 subsection 5. Now the seller will be the person who is going to bear all the expenses pertaining to putting the goods in a deliverable state, unless of course the parties have agreed to make some other agreement, because when it comes to taking care of the goods, it is always the person who is in possession of the goods who has to take care of the goods. And next, deterioration during transit, section 40. Now if the goods are to be delivered at a distant place, then the liability for deterioration, spoilage of goods incidental to the course of transit will lie with the buyer, even though the seller will agree to deliver it at his own risk, because the buyer is the one who is forcing the seller to deliver the goods. He's saying that he wants the goods delivered despite all of those problems. Therefore, it will be the expenses to be paid by the buyer himself. Okay, it will be the liability of the buyer. And next you have buyer's right to examine the goods under section 41. So just like whenever you buy clothes also, you always examine them, you try them out, you make sure there are no holes, no bruises on the clothes, right? Similarly, in case of contract of sale also, the buyer will always have the right to examine the goods. Now, if the buyer did not get a chance to examine the goods, then he is entitled to a reasonable opportunity of examining them. And the buyer has the right to ascertain that the goods that are going to be delivered to him are in conformity with the contract. That is, they have not been damaged, they have not perished. And the seller is bound to honor the buyer's request for a reasonable opportunity to examine the goods, unless of course it's already been mentioned in the contract that the buyer should not examine the goods. And the last point, you have delivery and payment are concurrent conditions. So this is under section 32, which states that buying the goods and paying for the goods should be simultaneous. Whenever you're buying something, you should pay for it immediately. Okay, so unless of course it has been agreed upon unless of course it has been agreed upon that it should be a credit sale or credit purchase. Okay, so this is with regards to the delivery of goods, all the rules pertaining to it. And next you have acceptance of the delivery of goods as per section 42. So with regards to acceptance of the goods, you know that in case of performance of a contract, the goods should be delivered, and once the goods are delivered, they should be accepted by the buyer. Then in that situation, it is said that a contract of sale of goods is performed. So a buyer is deemed to have accepted the delivery of goods when he informs the seller that he has accepted the goods, or when he does something to the goods which is inconsistent with the ownership of the seller, or when he retains the goods beyond a reasonable time without informing the seller that he has rejected them. So under these situations, we'll say that the buyer has accepted the delivery of the goods. So other sections that we can see with regards to goods as per the Act are under section 43, which talks about return of rejected goods. So if a buyer within his right, he refuses to accept the delivery of goods, then he will not be bound to return the rejected goods to the seller. However, he needs to inform the seller about his refusal of these goods. Now this is true unless both the parties has agreed to other terms in the condition or in the contract. Maybe they have agreed that goods cannot be returned, or maybe goods cannot be rejected. Then other than that, he will be liable under section 43. And you have under section 44, refusing delivery of goods. Now, if the seller is willing to deliver the goods and requests the buyer to take the delivery, but if the buyer fails to do so within a reasonable time after receiving the request, then the buyer will be liable to the seller for any loss due to his refusal to take delivery. Okay, he is also the buyer will also be liable to pay a reasonable charge for the care and also the custody of the goods until he accepts the goods or refuses the goods outright. And next we'll talk about the different conditions and warranties with regards to contract. So in a contract of sale of goods, various terms of stipulations are going to exist regarding the quality of goods, the price of the goods, the mode of payment for the goods, and then delivery of goods, and so on and so forth. Okay, all of these terms and conditions are going to be very important whenever you're entering into a contract of sale of goods. So it's usual for both the seller and the buyer to make representations to each other at the time of entering into a contract of sale. So some of these representations are just opinions which do not exactly form a part of the contract. However, there are some which may become a part of the contract of sale. So for example, if you're going to if you are going to buy something from a person, let's say you're going to buy a car, so you're just entering into a simple verbal contract. It's not a written contract, it's just an agreement between you and the seller, maybe, that says you want to buy a red color, you want to buy a white color car, or you want to buy a red color car, or maybe it says that you want to buy a car which is a top model car, or maybe you want to buy a manual car or an automatic transmission car. Okay, so these are just things that you are saying, talking to one another. So these may or may not form an actual part of the contract. So these representations are just basically mere opinions only at that point of time. So representations which do become a part of the contract will be termed as stipulations, and they may rank as conditions or warranties. Okay, so for example, if you're just saying the goods that you're selling are by a good condition, so these are not stipulations, but these are just opinions that you're giving. Okay, so they'll just be part of the opinions and they do not form a part of conditions or warranties. But if the seller assumes to assert a fact in which the buyer is ignorant, for example, if you are going to buy a product and you've already studied all the details, all the information with regards to the product, and the seller has not mentioned one or two details, and when you're mentioning these details to the seller, which then in that situation it forms a part of a stipulation which lead to an essential part of the contract of sale. Now, when we're talking about conditions and warranties, there are very clear-cut differences between conditions and warranties. Now, while some of them may not be important, some stipulations may be major terms which do go to the very root of a contract, which are very important for entering into a contract, and which may breach the contract, which may lead to a breach of the contract if they are not followed, if these minor terms are not going to be followed. So in the law of sales of goods, the major terms are called conditions and the minor terms are called as warranties. Okay, so you have stipulations, and stipulations are subclassified into major terms and minor terms. So the major terms are going to be called conditions and the minor terms are going to be called warranties. So let's look at the meaning of the conditions and warranties. So when we're talking about conditions as per section 12 subsection 2, a condition is nothing more than a stipulation which is essential to the main purpose of the contract, the breach of which gives the aggrieved party a right to terminate the contract, and in addition he can claim damages for the guilty party. So as we stated earlier in law of goods, in the law of sale of goods, the major terms are called conditions. So these are the very important or very crucial terms, and if there is a breach in the conditions of a contract, it could lead to termination of the contract, and they can also be sued for damages. And then you have warranty. When we're talking about warranty as per section 12 subsection 3, a warranty is a stipulation which is collateral to the main purpose of the contract, and the breach of which gives the aggrieved party a right to claim damages but not a right to reject the goods or to terminate the contract. And as we said, warranty is basically minor terms. Okay, so the minor conditions that are there, they are a part of the contract, but just a small part, a small fragment of the contract. In fact, they form a part of the conditions itself. So in case the warranties have been breached, you can claim for damages, but you cannot terminate the contract and you cannot reject the goods. So conditions are the very basis of a contract of sale. They are essential for a contract of sale. Therefore, any breach of conditions will make the contract void. However, in the case of warranties, the aggrieved parties can only claim for damages and they cannot terminate the contract. So there is no hard and fast rule as to which of the stipulations is a condition or which of the stipulations in a contract is a warranty. Okay, there is no straight cut method to identify the differences between conditions and warranties. So section 12 subsection 4 lays down that a stipulation in a contract of sale is a condition or a warranty. It depends in each case on the construction of a contract. So a stipulation may be a condition, though called a warranty in a contract. So when depending upon the condition, depending upon the contract that you've entered into, you can classify the conditions either as you can classify the stipulations either as condition or as warranties. Okay, so when it comes to conditions and warranties, the conditions sometimes can also be treated as warranties. Okay, remember stipulation subdivided into conditions and warranties. So sometimes conditions can be treated as warranties. So as per section 13, in cases of breach of a condition, they can also treat it as a breach of warranty. So these are the situations. Firstly, where the buyer waives a condition. So once the buyer waives a condition, he cannot insist on its fulfillment. For example, accepting of defective goods or going beyond the stipulated time amount to waiving a condition. Okay, so if he is willing to accept rejected goods, he's willing to accept defective goods, or if he's willing to wait longer for the goods, then it says that he has waived a condition, and in that situation, condition can be treated as a warranty, which means even though the condition has been breached, you cannot terminate the contract. Secondly, where the buyer elects to treat breach of condition as a breach of warranty, for example, where he claims for damages instead of cancelling the contract outright. And the third situation where a condition can be treated as a warranty is where the contract is not severable and the buyer has accepted the goods or part of the goods thereof, and then in that situation, the breach of any condition by the seller cannot be treated as a breach of warranty. It cannot be treated as a ground for rejecting goods unless, of course, it has been clearly specified in the contract. So therefore, when the buyer, after purchasing the goods, finds that the some of the conditions are not fulfilled, he cannot reject the goods anymore. He has to retain the goods, entitling him to claim only for the damages. This is in situations where he has accepted goods or part of the goods. Okay, in that situation, he can no longer terminate the contract, but he can claim for damages with regards to the contract. Okay, so this is the introduction with regards to conditions and warranties. We've learned about meaning of conditions and warranties and when conditions can be treated as warranties.